Ready, start. And the first thing done after the king's return, was to pass an act declaring this to be a good parliament, notwithstanding the defect of the king's writs, full stop. So that, as the royal prerogative was chiefly wounded by their so meeting, and as the king himself, who alone had a right to object, consented to waive the objection, this cannot be drawn into an example in prejudice of the rights of the crown, full stop. Besides, we should also remember, that it was at that time a great doubt among the lawyers, whether even this healing act made it a good parliament, and held by very many in the negative column, though it seems to have been too nice a scruple, full stop. It is likewise true, that at the time of the revolution, the lords and commons, by their own authority, and upon the summons of the Prince of Orange, met in a convention and therein disposed of the crown and kingdom, full stop. But it must be remembered, that this assembling was upon a like principle of necessity as at the restoration, that is, upon an apprehension that King James the second had abdicated the government, and that the throne was thereby vacant, which apprehension of theirs was confirmed by their concurrent resolution, when they actually came together, full stop. And in such a case as the palpable vacancy of a throne, it follows that the form of the royal writs must be laid aside, otherwise no parliament can ever meet again, full stop. For, let us put another possible case, and suppose, for the sake of argument, that the whole royal line should at any time fail, and become extinct, which would indisputably vacate the throne, in this situation, it seems reasonable to presume, that the body of the nation, consisting of lords and commons, would have a right to meet and settle the government, otherwise there must be no government at all, full stop. And upon this and no other principle did the convention in 1688 assemble, full stop. The vacancy of the throne was precedent to their meeting without any royal summons, not a consequence of it, full stop. They did not assemble without writ, and then make the throne vacant, but the throne being previously vacant by the king's abdication, they assembled without writ, as they must do if they assembled at all, full stop. Had the throne been full, their meeting would not have been regular, but, as it was really empty, such meeting became absolutely necessary, full stop. And accordingly, it is declared that this convention was really the two houses of parliament, notwithstanding the want of writs or other defects of form, so that, notwithstanding these two capital exceptions, which were justifiable only on a principle of necessity, within bracket, and each of which, by the way, induced a revolution in the government, bracket close, the rule laid down is in general certain, that the king, only, can convoke a parliament, full stop. The question whether there is scope for the union of India being responsible or liable as a joint tortfeasor is a difficult and different question. Full stop.